This topic covers the core ideas of real property law. First, the characteristics of property. Next, how property is different from contract law. Finally, why private property exists. Private property means a legal relationship with an object or resource. The legal idea is not just owning a thing but having certain enforceable rights. In everyday life, people think property means owning something. In law, property means holding rights in relation to that thing. Property is a bundle of rights. These rights include the right to possess, control, use, and exclude others. These rights can be separated or held together. A proprietary interest is in rem. This means it can be enforced against anyone. A contractual interest is in personam. It exists only between the people who made the contract. When you have a license, you can use someone's property, for example, to stay in a room, but you cannot stop other people from coming in or using it too. In the case Radaich v. Smith, the court said this clearly: a license is just permission, not control. In Street v. Mountford, the court said if you actually have exclusive possession, meaning you alone control the space and can keep everyone else out, then it is legally a lease, not just a license. In Cowell v. Rosehill Racecourse, a person went to the races and said that because they bought a ticket, they owned a special legal right over the racecourse, like owning part of the property. The court did not agree. The judges said the ticket only gave permission to enter, it did not give any ownership rights in the land. So the ticket was just a license, not a proprietary right, and the person could not use property law remedies to enforce it. When you have a mortgage, you don't fully own the whole property. Instead, the mortgage gives the lender a special legal right over the property as security for the loan. So a mortgage means the lender has a property right they can use if you don't pay. But a loan by itself is just an agreement between people, it does not give the lender any right over your property. It's just a contract, not a property right. Locke's labor theory says work gives the right to own. Bentham's utilitarian theory says private property brings general welfare. Kant argued ownership is about recognition. Marx said property should be shared but faced criticism for lack of incentive. Modern thinkers like De Soto, Macpherson, and Fitzpatrick give new views discussed in tutorials. Some resources cannot be privately owned. Res communes means resources like seas stay public. In Victoria Park racing, the court said a view cannot be owned. Human life cannot be owned for moral and human rights reasons. The common heritage principle comes from res communes. Resources in the high seas or outer space must be used to protect the interests of all nations. The finder's keeper's rule gives the finder good title except against the true owner. In Waverley BC versus Fletcher, the court said underground objects belong to the landowner. If an object is loose above ground, the finder keeps it unless the owner shows control. With consent, possession can be a lease for real property or bailment for personal property. Without consent, possession may lead to adverse possession if the owner does not reclaim the property in time. In Asher versus Whitlock, the court confirmed possession gives the right to use and enjoy property. The old concept of seisin has been replaced by the need for registered title. The Personal Property Securities Act sets rules for creating and enforcing security interests in personal property. It also sets the priorities between different interests. For real property, the main remedy is repossession. For personal property, remedies come from contract or tort. These can include damages, restitution, or injunctions. The Hepburn text has a helpful diagram at paragraph 1.32. Please subscribe, like, and leave any comments or questions.